Okay, our next topic is adjudication. Adjudication is what most people think of when they think about dispute resolution. Judge Judy, Judge Joe Brown, and all those other TV judges are adjudicating cases, usually disputes between a couple of parties, landlord-tenant disputes, boyfriend-girlfriend disputes, things like that. Okay, but the reality is that most cases, most civil cases, disputes, okay, disputes between individuals or between corporations, not between the state and people, those are criminal cases. But most disputes of a civil nature do not enter the adjudication process. I want to talk a little bit about what adjudication is. As much as you'd like to think that every divorce goes to court, virtually no divorces go to court anymore, and nearly every time it's handled via mediation or arbitration or a hybrid of the two called med-arb. But on to adjudication. Here, participation is non-voluntary. Okay, you don't get to say, oh, let's take it to court. No, this is not voluntary. The decisions in adjudication are binding, but they are subject to appeal. This is a difference from arbitration. Usually with arbitration, there is no appeal, but with adjudication, there is the possibility of appeal. Now, another difference between adjudication and arbitration is that whereas in arbitration, the parties involved select the decision maker, you and your spouse or soon-to-be ex-spouse pick your arbitrator. With adjudication, you are dealing with an imposed, determined for you, third party, neutral decision maker. Okay, and again, the important thing is to keep in mind is that in adjudication, like in arbitration, a third person is making the decision. Negotiation and mediation, the aggrieved parties are making the decision. Arbitration and adjudication, it's a third party. Arbitrators, by the way, tend to be professional and have specialized training. Okay, the formality of proceedings. In adjudication, you have something that is highly procedural. What does this mean? Well, it means that it is formalized and it is structured by predetermined, determined, and rigid rules. Okay, as you know, if you've ever been to court, even if you've just watched courts on TV, the proceedings, the way the court process proceeds, is governed by rules and regulations. And in fact, we talk about this in Unit 1-1. This is called procedural law. Procedural law. Okay. With regards to proof and evidence, just like with arbitration, each party has the opportunity to present evidence. And this is really important at both the arbitration and the adjudication stage because the decision of the third party is going to be based on the evidence that they are presented with. Okay, the type of decision, unfortunately, with adjudication, it's all about win and lose. It's all about a win and lose outcome. Now, with arbitration, you can have compromise, but with adjudication, you do not. And one of the problems with adjudication is if you're involved in a dispute with somebody that you need to have an ongoing relationship with, somebody's going to win and somebody's going to lose, and it's going to lead to a lot of anger and a lot of hurt feelings. I'm just hypothesizing here, but I think a lot of the time when you have estranged couples and one goes and kills the other or kills the kids or burns the house down, that's a case where a judge was involved, where the divorce or the separation was adjudicated. And then you have clear winners and clear losers. That's why, especially in divorce or when people have to continue with a relationship, usually arbitration is a better bet because that allows for some compromise. Okay, the justification when you're looking at adjudication, keep in mind that with arbitration, the arbitrator does not have to give a reason why he decided and the way that he or she did. But when a course is adjudicated, there is an expectation of a reasoned statement. In other words, the judge has to write up his or her decision and justify it. Justify it. Okay. All right, what is the emphasis in adjudication? The emphasis here is the process. And the process emphasizes attaining substantive consistency and the predictability of the results. In other words, this means that all things being equal, a judge that's hearing two divorce cases, if all the evidence is the same, if the circumstances are exactly the same, the judge will come up with the exact same decision. Okay? With an arbitrator, yes, the decisions are going to be similar, but there's some room for context. The arbitrator has a little bit of wiggle room to take special circumstances into consideration. Okay? And finally, the nature of the process. Well, when we're talking about adjudication, it is a completely public process. There is a lack of privacy regarding the case, and the results of the case are public knowledge unless the judge decides to seal the case. But again, if you want to air your dirty laundry in public when you're getting divorced, shoot for adjudication. But again, and this is just me speaking, but I think that a lot of the problems associated with using adjudication, when you've got people or businesses that need to continue their relationship, as in the case of divorced parents with children, adjudication may have the potential to cause more problems than it solves. Okay? If it is clearly something that the aggrieved parties have no hope of agreeing on, of compromising on, if it is a relationship that is broken beyond repair, then adjudication is an appropriate method of dispute resolution. All right, that is it for adjudication.